Good morning and welcome to this webinar organised by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe. The topic this morning is the EU procedural rights directives, latest developments for lawyers. My name is Jonathan Goldsmith, Senior Project Counsel with the European Lawyers Foundation. We have a lot of people joining us this morning for this webinar, and so while people are entering, I will make a number of important announcements. We encourage questions to be put in writing. You will see at the bottom of your screen, there is a Q&A, question and answers box in which you can put questions to our speakers in English. As I say, we encourage them. We will answer them if time allows it at the end of each session or maybe at the end of the webinar. Please do not use the chat for questions. Use the chat to say hello, to tell us where you're from, but put your questions for the speakers in the Q&A box. This webinar will be recorded, and the recording will be available on the European Lawyers Foundation's website, hopefully by the end of today. Two important issues on which we receive a lot of questions. First of all the presentations will be uploaded on the European Lawyers Foundation's website. I've seen the presentations, they're packed with extremely useful information. If our speakers don't have time to go through everything today, or if you haven't caught all the references, don't worry, they'll all be on the slides, which will be put on the Foundation's website, and you can consult them later. Secondly, if you're looking for a certificate for continuing legal education, we, the organisers, do not provide the certificates. You must approach your bar for a certificate. Your bar approaches us asking who has participated and for how long, your connection time. We give them that information. So don't ask us for the certificates, approach your bar. Now we begin the webinar. It's my great pleasure to introduce the President of the Council of Bars and Law Societies of Europe, Thierry Vickers, who will make some introductory remarks. Thierry was President of the Bordeaux Court of Appeal Bar Council in 2000-2001, chaired the Conférence des Bâtonniers 2004 to 2005, and the Conseil National des Barreaux from 2009 to 2011. He's also one of the three authors of Règles de la profession d'avocat, which in France is the reference book on the organization and deontology of the legal profession. Thierry, please.
Thank you, Jonathan, and good morning, everyone. It's really a great pleasure to open today's webinar. First, I would like to extend a sincere thanks to our co-organizer from the European Lawyer Foundation. Our long-standing partnership has produced numerous events on critical topics for the legal profession, from the digitalization of justice and anti-money laundering to our very recent session on the EU Charter of Fundamental Rights. Today, we turn our attention to another vital issue, the EU's procedural safeguard directives and the latest developments. This is a subject of core importance for CCBE. We were, as CCBE, heavily involved when those 6 directives were first being drafted and have since worked closely with the Commission on their implementation, evaluation, and ongoing assessment. This topic is also very timely. The push for more robust procedural safeguard was a key request in the CCBE May 2024 manifesto. So we are really delighted that the Commission has established a new high-level forum on the future of EU criminal justice, and that the CCBE is an active participant. In that context, I'm very pleased that Salvador Guerrero Palomares, chair of our Criminal Law Committee, is with us today. Salvador and his committee are currently preparing the CCBE official contribution to the forum with a strong focus on the very safeguard we are discussing today. Thank you, Salvador, for leading this crucial work. And this brings us to the heart of why we are here today. Procedural safeguards are not just theoretical principles. Their true value lies in their effective application by lawyers in our national courts. For us, as lawyers, staying current with these directives and their latest interpretation is not only important, it's really essential for upholding the rule of law in our daily practice. What will be our program today? It will offer both a high-level overview and a deep dive into 3 specific safeguards. To guide us, we have a great panel of very distinguished speakers, each bringing invaluable practitioner and institutional insight. I want really to thank Steva Franco from the European Commission, Salvador Guerrero Palomares, whom I have already mentioned, but also Nicola Canestrini and Alexis Adagnotakis. Both are esteemed members of the CCBE Criminal Law Committee. Thank you to everybody. Thank you to all of them for lending your expertise to today's events. Finally, I would like only to thank all of you, all our participants from across Europe and beyond. I wish you all an engaging and productive webinar. Thank you and have a good webinar.
Thank you so much, Thierry. Thank you very much indeed for your opening words. We now move on to the first substantive session. As Thierry said, we are very lucky to have with us a speaker from the European Commission. So the topic is the procedural rights directives, views from the European Commission, and our speaker is Steva Franco. Steva is a legal and policy officer at the European Commission DG Justice in the unit dealing with procedural criminal law. She joined the Commission 4 years ago after working in the criminal court in Rome, and her work in DG Just focuses on matters mainly relating to procedural rights, ne bis in idem, admissibility of evidence in cross-border cases, transfer of criminal proceedings. She closely follows the implementation of the 6 procedural rights directives and related recommendations on procedural safeguards. So, Steva, over to you, please.
Thank you very much, Jonathan, and good morning, everyone. I've been really well introduced. I would like to start with a warm thank you to the organizers, to the ELF and CCBA for today's webinar. I'm extremely pleased to speak today on behalf of the European Commission. I'm trying to share my screen, so give me a second.
That's it, perfect.
Great. Again, good morning. It's really wonderful to see such a strong interest and participation today. What I want to do today with you is to focus on the recent developments concerning the EU directives on procedural rights. These directives were adopted over a decade ago now. And so rather than revisiting their content, which I suppose is well known to an audience of lawyers, I want to concentrate actually on the latest developments of the interpretation provided on these directives by the Court of Justice of the European Union. The court's case law is of extreme importance since it determines not only how the directives have to be applied, but also how incorrect transposition can be challenges and how breaches of fair trial rights can be raised on a day-to-day basis. After presenting the case law, I will briefly go through what's the quid plus in the EU legal framework compared to the Council of Europe framework. And then I will dive into the Commission's role in monitoring and enforcement, including the current state of the infringement proceedings that are pending. And to conclude, I want to briefly conclude with a few remarks on future challenges, which I think might be of interest for everyone on the way forward from the institutional perspective. Starting from the very basics, following the Stockholm programs of 2009, the 6 procedural rights directives have been adopted from 2010 until 2016. They find their legal basis in Article 82.2 of the Treaty on the Functioning of the European Union, which provides the possibility to adopt at EU level minimum rules on the rights of individuals in criminal proceedings, with a view to facilitate mutual recognition of judgments and judicial decision, which is indeed the cornerstone of judicial cooperation in criminal matters. And these directives, as we all know, cover important procedural rights, which go from the right to interpretation and translation, the right to information, the right of access to a lawyer, the strengthening of certain aspects of the presumption of innocence and the right to be present at trial, procedural safeguards for children, and the right to legal aid. These directives do not stand by themselves. They are complemented by non-binding Commission recommendations, which cover vulnerable suspects, legal aids, and more recently, the Commission recommendation of 2023 on pretrial detention and detention conditions. As I mentioned, in recent years, the Court of Justice interpreted these directives in a steady way by way of preliminary rulings, while some of the earliest judgments date back to 2015, following, of course, the transposition deadlines of each one of the directives. The majority of important rulings were issued, I would say, in the past 3-4 years, and many more are expected. So far, the interpretation has mainly focused on the directives on interpretation and translation, information, access to a lawyer, and presumption of innocence, and there have been only very few cases on legal aid and children's, but we will go through them all today, or at least we will try at least to go through the most important one. So starting with Directive 2010-64, which ensures that suspects and accused persons who do not understand the language of the proceedings are provided with free and adequate interpretation and translation. Just a reminder that the key requirements included in the directive are, first of all, the establishment of a procedure or mechanism to assess the language spoken, and so the language needs by the suspect or accused persons. Then the provision of the right to interpretation at all stages of the proceedings, including of communication with the lawyer, and then the right to translation of essential documents, and finally the right to challenge negative decisions on the interpretation and translation and complain about the quality of the interpretation. And the Court of Justice already focused on a number of elements in interpreting these directives. First of all, the temporal scope of application. So in the Balog judgment, the court clearly clarified the scope of application of the directive, which is very similar to the scope of application of all procedural rights directives. And it goes from the moment where a person is suspected or accused of having committed a criminal offense until the conclusion of the proceedings. That is to say, the final determination as to whether the person committed an offense, including sentencing and the resolution of appeals. This was the very first judgment, and it was particularly interesting because the court also introduced an additional layer of interpretation by basically saying that as long as the fair trial rights of the person are safeguarded, then the scope of application of the directive applies as long as the person, let's say, is under trial. The Court of Justice interpreted the right to interpretation on one side in Kovaci and the right to translation of essential documents. As to the right to interpretation, the court clarified that when we speak of interpretation, we speak of the oral interpretation of oral statements. And so we only speak of oral communications. Instead, with respect to translation of essential documents in a number of judgments, the court clarified that the list of essential documents, which is included in the directive in Article 3, which imposes an obligation to translate all decisions depriving a person of his liberty, any charge or indictment, and any judgment, is non-exhaustive. And so the court clarified that it is up to national courts to identify any other essential documents which are necessary for an effective exercise of the rights of defense. And for instance, in case Sleutjes, in that case, the court clarified that, for instance, a penal order imposing sanctions for minor offenses is to be considered an essential document. And this is extremely important. And another case, which is case 242, of 2022. This is also important because in this case, the court clarified that national rules that impose that to raise violations of the right to interpretation and translation, this must be done within a prescribed period. And this period begins to run before the person has been informed, of course, in a language that the person understands, of the existence of those rights and of the content of documents which are essential for the person to be aware of the charges against them. Then these procedural rules are precluded. And why do I mention this judgment, which is very specific? Because in this case, the court, for the first time, but not really, because we will see that it did it also in other cases, the court delineated very specific procedural aspects by way of interpretation of the principle of effectiveness of EU law. Then we go to the directive on the right to information, which covers indeed the right to information about procedural rights, the letter of rights on arrests, the right to be informed about the charges and accusation, and the right of access to the materials of the case. In this, with respect to this, okay, you can see it now. With respect to these directives, also a number of clarifications have been provided by the court. First of all, on the right to information about the accusation. In this case, the court said that the directive does not regulate the specific procedures under which information about the accusation is provided. But again, by way of the principle of effectiveness, it clarified that these procedures, however they are according to the national systems, cannot undermine the objective of the directive, in this case, the objective of Article 6, which lays down the right to information about the accusation. And this was held in case Kovaci and case Moro. Then the court also clarified aspects related to the timing of the right to information. I mean, the directive already provides a number of requirements of the timing, but the court clarified with respect to information about the charges and to acquaint oneself with the case materials, that this information should be received in due time, basically at a point in time which of course allows the defense to prepare the defense effectively. And this was held in case Kolev and others. And then that as regards the rights, the information about other rights, which are the rights we're going to mention throughout the whole presentation today, this information should be provided as soon as possible, basically from the moment in which the person that are suspects to suspicions are subject to coercive measures, and at the latest before they're officially questioned by the police or by other authorities. So the timing of the provision of this information is very clear. The person must be aware of all their rights before they're questioned by the authorities. Then further clarification were provided on the legal classification of the accusation. This was quite a recent judgment, case 175 of 22. And in this case, the court clarified that, for instance, when ruling on the substance in a criminal case, a court cannot use a different legal classification of the acts compared to the one initially submitted by the public prosecutor's office, without the person having been informed of this change in legal classification and without the suspect or accused person having had the possibility to effectively exercise their rights of defense with respect to the new legal classification of the acts, even if this new legal classification is in favor of the defendant. And finally, case 660 of 21, KB and FS. And was a very interesting case because it deals with ex officio powers. So again, it delves very much into national procedural laws of the member states. And in this case, the court held that a national rule which limits a court to raise a breach of the rights of the suspects and accused persons ex officio is allowed only if the defendant was otherwise afforded full rights, in the sense that basically normally the directive doesn't preclude a situation in which a member state that does not allow a court to raise ex officio a breach of the rights of the suspects or accused person, as long as the person could have access to a lawyer, could have access to the file, and access to legal aid where possible. And again, this is an interesting judgment because it shows, first of all, the tendency of the court in maintaining an interpretation of the directives which preserves national procedural rules. Again, I want to remind that these directives do establish minimum standards of harmonization amongst the member states, but with the caveat that this remains the case only as long as these rules are effective in ensuring a sufficient protection of the rights of suspects and accused persons. The third directive is Directive 2013-48, which guarantees the right of access to a lawyer from the first stage of police questioning and throughout criminal proceedings. And I'm sure all of the audience today knows this directive very well. But also in this case, the court clarified a number of elements. First of all, on the scope of application. Actually, in these cases of the court related both to the directive on the right to information and the directive on the right of access to a lawyer. And first of all, the court clarified that these directives do apply also to judicial proceedings that authorize on therapeutic grounds committal to psychiatric hospitals of persons in a state of insanity. And then another very important case, which is case 209/22. In this case, the court clarified that it applies, the scope of the directive applies from the moment in which the authorities carry out the very first coercive measures on the basis of a suspicion. So the fact that national law does not recognize the concept of suspect and that that person has not been officially informed of being a suspect or accused person is irrelevant for the purpose of the application of the directives. And this is extremely important because the court clarified that the directive starts applying from very early stages in the proceedings. That is, from the very moment in which there is a suspicion against a suspect or accused person. And this judgment was extremely useful also from the perspective of the Commission to substantiate some cases that we still have pending on the transposition of the scope of the directive. First of all, against Bulgaria, which has an issue in transposing indeed in affording rights to suspects which are not yet detained. Other elements that the court clarified are related to the right of access to a lawyer. In this case, first of all, it clarified that the directive does not preclude national legislation requiring to dismiss a lawyer against the wishes of the client on the ground that there is a conflict of interest, as long as, of course, the suspect or accused person is always allowed to mandate a new lawyer. Then the court was asked also to provide interpretation on the restrictions to the right of access to a lawyer. And in this case, it was extremely interesting to see that the court, first of all, clarified that the list of exceptions under Article 3, paragraph 5 and 6 of the directive should be strictly interpreted. And then that these exceptions, if not transposed under national legislation, cannot be relied on by the authorities directly to derogate from the application of the right of access to a lawyer. This means that the exceptions, of course, not being an unconditional provision, they do not have direct effects. And if they're not transposed in national legislation, it means that that national legislation that does not allow for derogation on the right of access to a lawyer. And finally, case Stachev, which is case 1524, which was also, I would say, quite an interesting case in which the court held that national courts must be able to assess whether evidence has been obtained in breach of the right of access to a lawyer, and where appropriate, disregard the evidence. In this case, the interpretation was related to Article 12 of the directive. But again, the interesting part is that the court went a bit farther. It didn't go as far as to lay down a rule on admissibility of evidence obtained in breach of inadmissibility, let me be precise, of evidence obtained in breach of the right of access to a lawyer. But it clarified that, however, it must be essential that the court has the possibility, of course, to take into account when assessing the evidence that, for instance, the party was not in a position to comment effectively, that there was no access to a lawyer, and therefore that evidence has, let's say, a lesser probative value. Then we go to the directive on the presumption of innocence, which is one of the directives on which I'm directly responsible of. And in this directive, which I already mentioned, provide minimum standards for the protection of the presumption of innocence and the right to be present at trial. The court provided interpretation on two main elements. First of all, the prohibition of public references to guilt, and the right to be present at trial and the right to a new trial. On the prohibition of public references to guilt, this is a prohibition enshrined in Article 4 of the directive. And in two cases, the court clarified that preliminary decisions of a procedural nature based on suspicion or incriminating evidence are allowed, provided, of course, that they do not refer to the person as being guilty. This was mainly a case referring to those decisions, for instance, decisions on coercive measures at pre-trial stage. And then on the right to be present at trial, actually, the case law is already quite extensive, I would say. As you know, Article 8 of the directive imposes on the member states the obligation to ensure that the rights to be present at trial are observed. However, subject to certain conditions, trials can be held in absentia. And the court held that whenever the person is duly informed of the trial and they decide unequivocally not to appear, but were informed of all the steps taken in their absence, then the persons they are, let's say, then trials can be held in absentia as long as the person knowingly waived the right to be present at trial. And a very important case, a fundamental case, is case 569/20, in which the Court of Justice held that whenever conditions for having a trial in absentia and according to Article 8.2 are not met, and Article 9 on the right to a new trial comes into play, the provision is sufficiently precise and unconditional to be regarded as having direct effect. What does this mean? This means that any person having a right to a new trial may assert that right against the member state concerned before the national courts, either when the member states fail to transpose the directive into national law within the prescribed time period, or where the provision has been transposed but incorrectly. So this is extremely important because it gives to the single individual a right which is directly applicable. However, the court clarified that the right to a new trial can in certain cases be denied if it is apparent from very specific and precise indicia that the person receives sufficient information to know that he was going brought to trial, and that by deliberate acts and with the intention of evading justice, it prevented the authorities from informing the person officially of the trial. The court is continuing to provide interpretation on these matters. There are cases still pending now. And this is an interesting point because indeed the court clarified in several instances that there is a diligence to be exercised both by the authorities in informing the suspect or accused person of the pending trial, but also on the suspect and accused person itself in, of course, making sure that this is possible and in not evading justice. Then I will quickly go through the directive on children and legal aid, even if these two directives are also of extreme importance, simply because indeed, as I mentioned before, there is really few case law with regards to these directives. I mean, the directives on children is of particular importance because it provides novel participatory and child-specific rights. And there was only one case for the time being in which the court provided interpretation, which is case 603/22. And in this case, the court clarified a number of elements. First of all, that a child must always have a lawyer before questioning. Second of all, that the right to legal aid does not end automatically at age 18 without any assessment of the specific circumstances of the case. Then that both the child and the holder of parental responsibility must be informed of the rights before questioning. And finally, that national legislation which does not allow a court to declare inadmissible incriminating evidence contained in statements made by a child during questioning in breach of the right of access to a lawyer is not precluded, provided that the court is in a position to verify that the rights have been respected and to draw all interferences from that breach. I see that Jonathan turned on his camera, so it means that I'm running out of time. Do I have still 5 minutes?
Yes, there's one question, but actually we could take the question later and not for you because it's to do with the access to a lawyer, and we're going to have a specific session on that. It's about on the effectiveness of remedies provided when access to a lawyer is denied. But I think, Sveva, we can ask the specifics. We'll keep this question and ask the specific speaker to talk about remedies. You finish your presentation. You've got 3 more minutes, and we'll keep this question for later. Thank you.
Okay, great. Thank you very much. Given the 3 more minutes, I will just jump. I'm sorry, the slide on legal aid, but you will have this available, I understand, on the ELF site. There's just one case, a very recent case which is actually very interesting because it's on the right to legal aid and vulnerable suspects. But I would like to go directly then to, let's say, the role of the Commission in monitoring and enforcement, because I think this is one of the most interesting aspects, at least from the institutional perspective, on the role of the Commission as guardian of the treaties. As you know, the treaties empower the Commission to monitor and enforce the rights regulated under EU law, and this is, let's say, precisely the quid plus of the EU legal framework, that there is a way to enforce the rights that are recognized at EU level, and also where necessary conditions are met. As I mentioned before, some of these rights actually have a direct effect, and this is of extreme importance to challenge breaches of their rights in everyday practice. But what does the monitoring and enforcement role of the Commission mean? This role is mainly fulfilled by the Commission working closely with the Member States to monitor the implementation of the directives and practical application of the directives in the national practice. This means that once the transposition deadline passes, the Commission carries out compliance assessment of national measures with the support of stakeholders, such as lawyers, associations, external contractors, and legal experts in each member states. On this basis, the Commission gathers input on the national transposition, and then we publish implementation reports which are available online. Implementation reports for all the directives have been published, and the latest one have been on the Children's Directive and on the Legal Aid Directive. On the basis of the shortcomings that are identified with these compliance assessments, the Commission may open infringement proceedings. I think this slide might be of particular interest because indeed, as you probably know, there are two types of infringement proceedings. So infringement proceedings for incomplete transposition, which deal with manifest gaps in legislation. It means that the member states did not at all transpose a provision, and infringement proceedings for conformity, which are cases in which national transposition exists but is not correctly transposed. And as you can see from the table, while for the children directives we still infringement pending on the completeness of transposition. On all the other directives, with the exception on legal aid, for which infringement and enforcement will soon start, we have quite many, especially for the directive on presumption of innocence, infringement pending. So lately, actually, our attention focused on presumption of innocence and access to a lawyer, but this is just to say that the work ahead is still long. But in many instances, we have seen great results in practice of our enforcement work. Member states have amended their legislation. This, of course, I'm referring to the Red Directive on Interpretation and Translation and the Directive on the Right to Information. And I always want to make the case of the right to translation in Portugal, which was completely missing, and following an infringement procedure by the Commission. Now we have actually legislation which clearly sets out this right. And I will briefly conclude by simply leaving you with this slide, which, let's say, shows what are the future gaps. First of all, the priority, again, will be to focus on enforcement. And the second priority is to actually fill in the legislative and policy gaps. So it was already mentioned by Thierry at the very beginning that we launched this reflection, the high-level forum on the future of EU criminal justice, which brings together a range of stakeholders to discuss the future of EU criminal law. And some of the topics that you see here, actually all of them, are currently being discussed in this forum to indeed see where to go in the future. This process will be finalized by the end of this year. And I thank you very much for your attention. And I'm sorry if I took too much time. Thank you, and happy to answer all your questions.
Thank you, Sveva. There's one question that's come in about the transposition of the e-evidence regulation, which I think may not be your responsibility. But if you know anything about it, can I ask you to write? You can write in the answer. If you do know the answer to the question about which member states face penalties for delay on the e-evidence regulation, please write in the answer. But we ought to thank you very much indeed for your very full and excellent presentation. But we ought to move on because of time. So our next session is on the latest development on the right of interpretation and translation and the right of access to a lawyer. Our speaker is Nicola Canestrini. Nicola is an Italian criminal defense lawyer. He defends rights in and outside the courts. Main fields of practice are Italian and European criminal law, Italian criminal defense, international criminal cases like extradition, European arrest warrant, European investigation order. He's rights of audience in the higher Italian courts and also qualified to practice before the International Criminal Court. So, Nicola, over to you.
Thanks a lot, and thanks for inviting me as well. I am going to speak to you, dear colleagues, about a topic which is one of the most important fair trial rights. Let's be more specific. It is the most important pre-right for every fair trial, because we cannot even speak about right to assistance of a lawyer, the right to get the case file information, presumption of innocence. It makes no sense if someone does not speak or understand the charges and cannot interact with the court, isn't it? And despite that importance, I'm going to spoil the end of my presentation. It is one of the most non-effective rights in maybe EU from my knowledge, but for sure before Italian courts. Let's see if I can convince you in the next few minutes. So as everybody of us knows, European Union stands and lives because of its of the importance of fundamental rights in our community. It is clearly stated in the founding papers. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, rule of law, and respect for human or fundamental rights. And Article 6 of same treaty, fundamental rights as guaranteed by the European Convention for the Protection of Human Rights, and as they result from the constitutional traditions common to the member states, shall constitute a general principle of the union laws. General principle meaning that even the legislator could not overrule them without modifying the very essence of our decision to live together. Of course, fundamental rights in EU are upheld and provided for in other important international treaties, European Convention on Human Rights and Fundamental Freedoms, and of course, the EU Charter. This shouldn't wonder us that much, isn't it? Because when it comes to European Union, everybody of us thinks about mutual recognition principle, the fact that it's based on mutual trust. If I'm speaking about the area of freedom, security, of justice, post-Tampere 1999. But if we can say that mutual recognition is based on trust, what is trust based upon exactly? It's exactly based upon rights. We can speak about mutual recognition if we have mutual trust, and if to have mutual trust, to trust the judicial decision of another member state, it requires the knowledge that rights, fundamental rights especially, are equally protected in the criminal procedure. That was the Article 82 of the Treaty of the Functioning of the European Union, which was mentioned by the brilliant speaker before. And if you don't believe, a small a lawyer of a small law firm in northern part of Italy believed the Dorobanto judgment 2019. It was about detention conditions and development of the landmark Aragnosi and Calderario case of 2016. But in the Dorobanto case, Luxembourg ruled that both the principle of mutual trust between member states and the principle of mutual recognition are in EU law of fundamental importance, given that they allow an area without internal borders to be created and maintained. And the principle, specifically to the point that I was raising with the slides before that, the principle of mutual trust requires, save in exceptional circumstances, those that are so important in European arrest warrants defense, to consider all the member states to be complying with EU law, and particularly with the fundamental rights recognized by EU law. No mutual trust, no mutual recognition without trust, no trust without knowledge or presumption that every other member state complies with EU law and in particular fundamental rights. So for example, right to life, clearly the cornerstone of the convention, the prohibition of torture, inhuman or degrading treatment, ruled upon by Article 3 of the convention, Article 4 of the Charter, and the other fundamental rights provided for, which do full include the right of fair trial, Article 6 of the Convention, Article 47, 48 of the Charter. Article 6 particularly, 6.3 letter E, coming to our topic, is the right to have the free assistance of an interpreter if he or she cannot understand or speak the language used in court. It's completed by, as mentioned, by Article 47 and 48 of the Charter. Everything's fine. But you had then to recognize, probably because Italy gave a huge contribution to this knowledge with its interpretation of fundamental rights and fair trial rights. I'm thinking about the in absentia saga. I was 12 when Italy was the first time convicted for the in absentia non-effective knowledge of criminal proceedings, and I was quite over 45 when Italy was sanctioned the last time. So Italy does contribute to development of EU law broadly said, and in the Court of Justice, as you may know, 2 or 4 or 5 landmark cases regarding bans of surrender in European arrest warrants came from Italy. It was the ADL case, the right to health, and the other one was GN case, the best interest of the child, which gave 2 new bans for surrender in European arrest warrant cases based on fundamental rights defense. So because there was this idea that probably the fact that every EU member state was part of the European Convention of Human Rights was not completely enough. It was the Bosphorus presumption. So better said, it was the fact that EU member states and the EU legislator recognized that being part of the convention was not enough to ensure fundamental rights for everybody. That's why at some time the legislator decided to enact procedural directives. So we had heard from them. So it will be a little bit easier for me to go through that topic. And so there was a need for the EU procedural rights established with the Swedish roadmap of 2009 and then enacted, as we saw, with the procedural directives, which I rewrote on this slide. It is important to note that the roadmap was designed to operate as a whole, and now that we have this whole roadmap legislated upon and mostly implemented in member state, and thank you, Zueva, for a very useful upgrade about the state of implementation and the infringement proceedings that you share with us. The first procedural right was exactly the right to interpretation and translation of 2010. So we have a lot of instruments, founding treaty, common constitutional traditions. We have the convention, the charter, the procedural rights directives. And so our job should be done in ensuring fundamental rights, isn't it? It isn't, because just trying to stretch it a little bit for the audience. When we speak about fundamental rights and effective and practical rights, as they should be, following once again an Italian decision against Italy, it was the decision because of the behavior of the court-appointed lawyer, which did not grant language rights to his client. Exactly, we're speaking about interpretation and translation issues here. In article against Italy of 1980, Strasbourg ruled that the convention, and we would say EU, needs to grant rights that are not theoretical and illusionary, but practical and effective ones. And I think when we speak about theoretical or illusionary rights, the first example which came to my mind is exactly the right of interpretation and translation, because the scope, the idea, the rationale behind the Directive 64 is to ensure that defendants, not prosecution, not victim, but defendants have a fair trial. And this means exercise the rights of defense and safeguard the fairness of the proceeding. It has an individual and a collective dimension. And as we know, and as some of us have surely noted, a Strasbourg case law does not really ensure this fundamental right as really fundamental. Okay. So, for example, the translation in writing is not mandatory under Strasbourg case law interpreting the Convention, European Convention of Human Rights. There is no right under Article 6 of the Convention to have a full translation of the court files. And often, oral translation is enough for the court, Strasbourg court, to say that from the broad perspective, which is the perspective of Strasbourg in judging Article 6, the respect of Article 6, in national proceedings, the oral translation will do it, which gives us a first and fundamental a hint for us defense of the criminal attorneys, which is if there is something wrong with fair trial rights, especially the interpretation and translation rights, put that in the minutes. It is more important that we can believe that the minutes of the hearings reflect what happened there. For example, if the interpreter or translator does not, also the interpreter does not interpret correctly, if there are issues, it should be always documented in the minutes, not only because the national court is the first interpreter of the convention, and if you want then to go to Strasbourg, we need to prove that we raised the complaint in national proceeding, but even to give the Strasbourg court an exact overview what happened. I know that we defense attorneys, we are not able to always to decide what comes in the minutes, what comes not. But I'm sure every legal system throughout the EU gives the lawyers a chance to interact during the hearing or to file a brief or a complaint immediately after the hearing, which are the cornerstones of the Directive 64/2010. It's the quality. And if we need to assess quality, we need to have in mind what's the scope of the directive. So assure a fair trial, let's say a collective dimension, and the rights of the defense in the very specific proceeding, which means it's the defense that has to be interacted with when it comes to assess if there is enough quality, yes, no. So even if, let's say it friendly, maybe judicial authorities are not so keen to stop the efficiency of criminal proceeding because the court needs to take care of fundamental rights of the defendant, it's exactly the defense that has which needs to raise questions about quality. For the quality, it's provided for, let's say, the directive speaks about interpretation when it comes to oral interpretation and to translation when it comes to written interpretation. Okay, so it's ensured both for interpretation and translation, so for verbal and written translation. It provides for training in that respect, and it has no cause for individual, which is of course a big improvement in theory. Regarding the interpretation, the column on your left, there should be an assessment mechanism if there is the need of interpretation, and this assessment is clearly ruled. The police officer asks the defendant saying, do you speak or understand Italian or Greek or Portuguese or German? And depending on the answer, the knowledge is assessed, because that's what happens every day. So this mechanism is just the question about police officer. Because if it's true that the directive speaks about the fact that it should be the judicial authority to assess if the language is understood and spoken to the effect to ensure fair trial and rights of the defense. But this is a very weak safeguard, because what does the Italian judiciary do? They rely on the police minutes. So formally, the assessment of the need of interpretation translation is made by judicial authority, but they rely on the minutes of police. So at the end, it didn't change anything before and after the Directive 64. It's always police assessing if there is a need for interpretation translation. And you know what? I don't think that's really the job of a police officer. The police officer is very good in searching for evidence and in making investigation, proposing or carrying out investigative acts. But I don't think that the police officer who barely speaks French, German, Portuguese, do you name it, English, whatsoever, can assess if the level of understanding is enough to ensure fair trial rights. Because one thing is to say come ti chiami and saying then your name or da dove vieni or whatsoever, and the other thing is to grant to a certain extent the more complicated communication. And if you read out a letter of rights in Italian to a foreigner and then you say firma qui, sign here, the guy or the lady will probably sign without knowing that this excludes him from claiming the right to speak a language of his mother or her mother language, or a language that he or she can fully understand. Then regarding interpretation, the directive requires to set a register of independent translators and interpreters, which is perfectly fine. And Italy does always state with the EU institutions that we have this register of independent experts, which is true as well. But nobody tells the Commission, but we will, as I'm going to explain in a minute, that nobody checks how in Italy you come on this list. Basically, if somebody in Italy will get on the register of independent translators and interpreters, one goes to the Chamber of Commerce, which is an institution which has nothing to do with judiciary, makes an oath to understand and to speak that given language, let's say Malaysian. And then with this certificate from the Chamber of Commerce, you go to court and you will get your name on this list of independent translators or interpreters for Malaysian language, which means then that you will be summoned in court. Nobody can question your work. And even if, as I did once, even if the interpreter and translator admits not to speak to a sufficient degree that language, the president of the court in Italy has not the power to review this list of independent experts and of independent language experts, let's call them like that. So the fact that we have a list of independent translators and interpreters in Italy does not conflict with the fact that it's a completely theoretical and illusionary right, because the problem behind that is that being on this list does not grant you the quality of the service of interpretation and translation. Beside that, under Italian case law, it is not mandatory for a court to pick the interpreter translator up from this list. Better said, it is mandatory, but it has no sanction. And as we know, as lawyers, as we know very well, when it comes to mandatory requirements or conditions, if there is no procedural sanctions or a very weak procedural sanction, let's say like disciplinary sanction, this does not prevent infringements to happen. The interpretation rights should be granted to defense as well. and in my 25 years of experience, and let's say 15 from the enactment from when the directive was ruled on by European legislator, what happened in the last 15 years was, when I ask for an interpreter, I get an inmate who speaks the same language as the defendant if the defendant is in jail. An inmate coming from, I don't know which country, with no studies, of course, with absolutely no idea about the ethical duties and the technical duties of interpreters and translators, and maybe without any knowledge of the cultural background of the criminal procedure except its own. And this may lead to other major problems as well. We have seen, for example, that for who is following Strasbourg case law on Article 6 in the Amanda Knox case, we will touch upon briefly in some minutes. Regarding the translation rights, so the translation of the case file in writing, it was a strong needed provision because, as you remember, Strasbourg does not deem it necessary or mandatory to ensure the fair trial rights with a written translation. And maybe it would be difficult to explain to some guys charged in Italy with a 30,000, 50,000 pages case file to say that Article 6 rights are perfectly respected if some interpreter just make his or her own resume of the content of the case file. Of course, technology helps us. Artificial intelligence and people are very effective in ensuring these translation routes, but still we would probably need something more, because the directive provides for a mandatory list of documents that has to be translated. For example, every decision, judgment, or pre-trial detention decision. We'll see how Italian judiciary is going to interpret that, and there may be space for infringement procedure as we come to it. But the fact is that beside very few mandatory acts to be translated, the summon in court, for example, there is a lot of space, a lot of room for improvement, let's say it like that, in assessing which documents should be translated, because the directive rules that this mandatory translation duty applies only to essential documents. And what does essential mean? Who is going to establish what essential means? You know the answer already. Prosecution, or if it's a very developed and a very careful environment, court. But that's not completely accurate. Let's say
Nicola,
yeah.
only just to remind you, you're coming towards the end, but there is a question on all of this. So I thought, and before you get on to the Knox case, which I see is a European Court of Human Rights case, there's a question about how does the Luxembourg Court, the Court of Justice of the European Union, assess the quality of interpreted evidence? Has there been a case to that effect, and how does it do it? Thank you.
No, never. Coming to the case law of Luxembourg, the problem is that Luxembourg is not really aware what is happening in national courtrooms. Beside that, there were the first decision on this procedural directive was 10 years ago, the Kovaci case, in which the defendant filed with the criminal penalty, with the penal order, filed his defense briefs in his mother tongue, which was Romanian, and the proceeding was German. And here the court stated that there was not the right to submit written briefs or statements to the court in the mother tongue of one of the citizens of the European Union, which is a pity because it started with narrowing the interpretation. The good news is in the TL case, which was quoted before as well, is that one of the trickiest things for us defense attorneys are deadlines in which the breaches have to be submitted to the court. And this is exactly the problem of Italy, in which every breach of the language rights do belong to the category of the rights of the defense, and they have to be mandatory raised during the proceeding within a given time frame. In this regard, I do welcome the good news which came from Luxembourg with this DL case, saying that if there is a deadline running, the deadline cannot run until the fact that there is a deadline running has not been translated to the defendant, which is okay. Due to the fact that I will skip some important slides, but you will have them available. I will just mention that Italian Constitutional Court ruled in February this year on a constitutional complaint raised by Florence Court that the effectiveness of a right depends of the compensation of interpreter, because some of you may not know that in Italy, interpreters and translators got 4 hours gross for the first 2 hours, 7 euros gross, sorry, for the first 2 hours, and 4 euros gross from the 3rd hour on. The Constitutional Court said that this cap from the 3rd hour on was not legitimate, so now interpreters and translators can celebrate because they will earn 7 euros gross for every hour of their job. Beside that, we launched an action in Europe with the hashtag No Translation, No Justice, in order to make the Commission aware and the stakeholders that there's something not working. And I hope soon we will ask the Commission to launch another infringement procedure against Italy regarding the interpretation and translation rights. Somebody always asks, especially if I am intervening with courts, police forces, or prosecutors, that this is going to be a problem for international criminal cooperation if you have to take care of fundamental rights or fair trial rights and interpretation translation rights. And in this regard, I would like to conclude quoting a 40-year-old statement of Italian Constitutional Court again, saying that the requirements of international criminal law enforcement must not infringe upon fundamental rights. And I think that should be our point. I'm sorry, Jonathan, thanks a lot.
No. Absolutely fascinating. Thank you very much indeed. I'm sorry we had to interrupt you, but we must get on. Excellent, Nicola. Thank you so much. We do move on so we don't lose time. And we come on to our next session, which, when my notes will open up, is latest developments on the presumption of innocence. And our speaker has already been name-checked by the president of the CCBE, and it is Salvador Guerrero Palomares. Sorry, there was a small error in the program in his name, for which we apologize. Salvador is the chair of the CCBE's Criminal Law Committee. He's been a criminal lawyer in private practice since 2000. He's a PhD and associated professor of procedural law at Malaga University. So, Salvador, over to you, please.
Thank you, Jonathan. Everybody can see my presentation on the screen?
Yes, thank you.
Okay, well, good morning to everyone. First and foremost, I would like to extend my sincere gratitude to the European Lawyers Foundation for the kind invitation to participate in this seminar and to share a few reflections on procedural safeguards, particularly on a subject that I consider it's one of the most important principles of the criminal proceedings, the presumption of innocence. My remarks today will focus on the evolution of this fundamental right within the European context in recent years, with particular emphasis on the most recent case law of the European Court of Human Rights and the European Court of Justice. Before turning to the core of my presentation, allow me to briefly revisit the legal framework underpinning the presumption of innocence. At the European level, as you know perfectly, the presumption of innocence is set up in the following legal instruments. Article 6.2 of the European Convention of Human Rights, which states everyone charged with a criminal offense shall be presumed innocent until proven guilty according to law. Article 48 of the Charter of Fundamental Rights of the European Union, which provides that everyone who has been charged shall be presumed innocent until proven guilty. And the Directive 2016-343 on the strengthening of certain aspects of the presumption of innocence and the right to be, present at trial. Article 3 of the directive states member states shall ensure that suspects and accused persons are presumed innocent until proved guilty according to law. This directive is of particular significance that it establishes harmonized minimum standards in procedural safeguards across the member states. Although it entered into force in 2016 and was due to be transposed by April 2018, not all members have complied, as we will be discussed later. In essence, the directive codifies the most salient elements of the European Court of Human Rights jurisprudence on the presumption of innocence, especially as developed in key judgments such as Barberame, Segea, and Javardo, Minelli, Secanina, or Allen. The directive, in fact, reflects the two core dimensions of the right as the European Court of Human Rights had established. First, the presumption of innocence as a rule of evidence at trial encompasses principles such as the burden of the proof rests with the prosecution, the in dubio pro reo principle, and the right not to self-incrimination, Articles 6 and 7 of the directive. And the second aspect of the presumption of innocence, the presumption of innocence as a principle with extrajudicial implication, which finds expression in Articles 4 and 5 of the directive. These provisions prohibit public authorities from making statements implying guilt prior to a final conviction and oblige these public authorities to ensure that the pre-trial measures do not represent the accused as a guilty by means of physical restraint or coercion unless necessary, of course. This directive, in fact, marks a significant step forward towards greater procedural fairness, requiring states to protect the dignity and public image of individuals even prior to the adjudication of guilt. Nevertheless, what is the practical reality observed by legal practitioners on our daily basis? Regrettably, we are faced with a landscape marked by substantial deficiencies. In many instances, the effective application of the presumption of innocence is difficult to discern. Among the most salient issues we found, or at least in my opinion, we found the following problems. First, the predisposition of certain judges who approach trials with an implicit bias towards conviction, reflecting a subjective interpretation of the presumption of innocence. Defense lawyers frequently perceive a reversal of the burden of the proof, whereby the defense is expected to demonstrate the absence of guilt rather than the prosecution proving it. Second, the phenomenon of trial by media in high-profile cases, which subjects individuals to reputational damage and de facto sanctions before they have been lawfully tried. The continued practice by public authorities of issuing statements that imply guilt, contrary to the express prohibition set forth in Article 4 of the directive. And finally, the incomplete or inadequate transposition of the directive in many member states, particularly with respect to the presentation of suspects before courts or in the media. As we saw a few minutes ago in the first presentation, infringement proceedings have been initiated against against many member states. Against this backdrop, I now turn to the principal theme of this presentation, the recent developments in the interpretation and application of the presumption of innocence by the Strasbourg and the Luxembourg courts. Regarding Strasbourg court, regarding European Court of Human Rights case law, its study reveals a concerning regression in the level of protection of the right to be presumed innocent, as we shall see. As regards the ECJ case law, there has been comparatively little development. Few preliminary references has directly addressed the presumption of innocence as such. Indeed, I have identified only one significant judgment in recent years. The court has, however, addressed most frequently the right to be present at trial, but this is a different right and falls without the scope of this presentation. We are going to examine two decisions of recent decision of the European Court of Human Rights and one recent decision of the European Court of Justice. Just started with the case that you have in the slide, Nielon and Hallan against United Kingdom, 11 June 2024. Summary of the case. Nielon and Hallan were convicted of serious crimes, serious offenses, rape and murder, but the judgment was quashed by the Court of Appeal because the convictions were unsafe. They sought compensation under national law, namely Section 133 of the 1988 Act, which required them to demonstrate, to get a compensation after the acquittal, they need to demonstrate beyond reasonable doubt that there was a miscarriage of justice. This is what the Section 133 of English Act 1988 states. The applications to get compensation were refused, as the applicant under the UK courts, the applicants had not satisfied the test in the aforementioned section. What is the legal issue at stake in this judgment? Does the denial of compensation on this basis infringe the presumption of innocence? Well, surprisingly, the European Court of Human Rights held that no violation had occurred. The Strasbourg Court states that while Article 6.2 was applicable, states were deemed to have discretion regarding compensation standards. The court accepted that as long as the reasoning of the authorities did not use the expression of guilt, not attribute criminal liability to the applicants, their presumption of innocence remained intact. In paragraph 180 of the judgment, the court states, "It could not be said that the refusal of compensation by the Justice Secretary imputed criminal guilt to the applicant by reflecting the opinion that he or she was guilty to the criminal standard of committing the criminal offense." So we can see that the judgment is based on the language used by the United Kingdom administration courts and after that the courts. In my opinion, this is a very, very formalistic approach if the approach is based just in linguistic considerations. This ruling introduces a dangerous precedent in which individuals legally exonerated must bear the burden of proving their innocence to obtain reparation. These standards, in my opinion, erodes the essence of Article 6.2 and undermines the social and legal significance of an acquittal. But furthermore, this judgment departs from previous precedents of the same court in relation to the application of the principle of presumption of innocence in proceedings for compensation for pretrial detention on miscarriage of justice. For example, in Secanina against Austria or in Blieland Body and Marcelo Lani against Spain. In Secanina, 1993, the court stated that once there is a final acquittal, the authorities cannot act as if the accused is guilty. A refusal to compensate is acceptable if it is based on grounds other than criminal guilt. For example, technical reasons or lack of objective evidence, but not if it is based on a persistent suspicion of involvement in the offense. Sorry. In Secanina, the court concluded that Article 6.2 had been violated because the reasons given by the National Court implied a persistent suspicion of guilt, which undermines the presumption of innocence after acquittal. In Blieland Body and Marcelo Lani in 2016, the court reiterated the Secanina way of thinking. As you can see, the approach now it's totally different in Mialon and Hallam. But all is not lost because fortunately there was a dissenting opinion of 5 judges that strongly opposed the position of the majority, arguing that the requiring proof of innocence effectively violates the right of the presumption of innocence. The sentence, the judgment, Mialon and Hallam, was approved 7 against 5. So probably in the future, when the composition of the court will change for sure, maybe a different majority could come up. Second case, CO against Germany, 14th September 2024. Summary: the applicant, CO, involved in the so-called cum-ex tax fraud scheme, was not tried or convicted. Nevertheless, co-defendants were tried, sentenced, and convicted in a case in which CO wasn't involved, and in the case that the co-defendants were convicted, the judgment described CO as an instigator and co-perpetrator of the crime, despite of the fact that CO, I insist, wasn't involved in the case as a defendant. What's the legal issue at stake? Does such a portrayal in the judgment of others infringe Article 6.2 of the European Convention of Human Rights when the person concerned has not been tried yet? Well, the European Court of Human Rights held again that no violation had occurred. Why? Because of the language used by German courts. Again, the language. It is true that the German courts tried to avoid and refrain from issuing a formal finding of guilt regarding, say, CO. German courts do not say expressly that CO is guilty. CO was every moment referred as to being separately prosecuted, but the German courts did not say CO is guilty, but describe facts that means that he is. The Strasbourg court emphasized it again that the language used did not prejudge the criminal liability of CO. In my view, again, this interpretation is overly formalistic. The German court did not expressly state that CO was guilty, but described facts that made him an instigator and co-perpetrator of those acts in the context of a trial in which he was not involved. The protection of human rights cannot hinge on stylistic nuances or legal drafting techniques. The description of criminal conduct, even without a formal declaration of guilt, undermines the presumption of innocence when the individual has not yet stood trial. As you can see, this could be considered as a regression in the protection of the presumption of innocence within the scope of the European Convention. Let's turn now to the European Court of Justice. As I told you at the beginning, there weren't too many judgments lately. In fact, I have just found one judgment in case 175/22, 9 November 2023. The previous speaker, Seveva, has explained some older decisions concerning presumption of innocence dated 2018 and 2019. Summary of the case mentioned on 9 November 2023. In Bulgaria, a police officer was tried for corruption. During proceedings, the trial court reclassified the offense as fraud or influence peddling without notifying the accused beforehand, which is allowed by Bulgarian law. The specialized criminal court in Bulgaria lodged a preliminary ruling asking the court, among other things, if the second paragraph of Article 47 allows the court to reclassify the offense by itself, taking into account that this reclassification does not come from the public prosecutor's office. As you can see, the Bulgarian court did not mention the presumption of innocence, did not mention Article 48 of the Charter, and did not mention the directive. But the European Court of Justice, lying on its own case law, for example, in judgment in case 61/21, reformulated the question and understood from the explanation provided by the referring court that the matter was directly related with the right to be presumed innocent. What are the key questions here? Well, does that situation, that procedural situation in which the court, in a sense, taking the role of the accusation, changing the classification of the offense, does this violate the right established under Directive 2016-343? Or saying in another words, does such a reclassification compromise judicial impartiality, thereby infringing the presumption of innocence that obliged the court to not have any preconceived idea that the accused has committed the offense? Well, first of all, the court, answering a first question on the preliminary ruling, the court held that the directive on information precludes a practice whereby the accused is not informed in sufficient time to prepare an effective defense against the reclassification. So the Bulgarian court, first of all, asked, is according to the directive on information to reclassify the offense without warning the defense. And the court says, obviously, this is against the directive on information. You should inform the defense with enough time to prepare the defense. But however, regarding the second part of the preliminary ruling, which is important for us in terms of, we are talking about presumption of innocence. However, with regard to presumption of innocence, the European Court of Justice found no violation, provided the accused is informed sufficiently in advance and is afforded the opportunity to exercise his defense rights effectively. So, as long as the court has duly informed the defense about the reclassification, this reclassification, despite of the fact that this is a reclassification made by the court and not by the public prosecutor, does not violate the presumption of innocence according to the European Court of Justice. I have different opinion. I would submit that such judicial initiatives undermine the separation of roles in criminal proceedings. When a court assumes prosecutorial functions as reclassify an offense, they are losing their impartiality in a way. As a conclusion, I am now finishing. One can say that we are not living good moments for the presumption of innocence. Presumption of innocence is far more than a procedural formality. It's a foundational principle of democratic criminal justice and a safeguard for human dignity. But the developments at the EU and at the Council of Europe level reveals progressive deterioration of the guarantee that implies the presumption of innocence. Transforming this principle into a tangible reality in all member states must remain a shared enterprise among judges, legislators, and defenders of the rule of law. And we, as lawyers, are defenders of the rule of law. So please do not hesitate in bringing cases to the European Court of Human Rights, and try that the tribunals of your jurisdictions issue preliminary rulings before the European Court of Justice, and let's try to put forward good allegations in favor of the presumption of innocence. It is important to preserve the presumption of innocence, and it is necessary. Thank you very much for your attention.
Thank you so much, Salvador. Excellent as always. Very interesting, very good. A question came in, but actually I think it's a question for Nicola, which is why I didn't interrupt you. But I mean, I'm happy for you to answer it, or Nicola can write an answer afterwards, from Duncan Gren from Ireland, saying, apart from preliminary rulings via hearings of written submissions, when evidence is presented orally via an interpreter, how does the Court of Justice ascertain that it's not merely an interpretation of the oral evidence, but rather an accurate translation of it? I don't know whether you want to answer it, or Nicola can answer it in writing, and we can move on.
I think this is for Nicola.
Right, exactly. It's Nicola's question. But Nicola, if you could answer it in writing, if you would, Nicola, thank you. Thank you, yes. And we'll move on, since we should keep to our time. So this is now our last session, and I would like to welcome our last speaker. So this session will be on latest developments on the right to legal aid. The speaker is Alexis Anagnostakis. Alexis has been a criminal lawyer in Athens since 2002 and is a barrister before the Hellenic Supreme Court. Like Nicola, he's been admitted to the International Criminal Court's list of counsel. He's a member of the International Criminal Court Bar Association and is on the board of the European Criminal Bar Association and chair of its Human Rights Committee. So Alexis, over to you, please.
Thank you very much, Jonathan. Thank you very much, firstly, for pronouncing mine correctly. That means it's not all Greek to you. And secondly, for your overly generous introduction, that I will try to live up to that. So I will share my screen. And
that's it. Perfect.
okay. So thank you very much. So for the final session, Jonathan and dear attendees, I'm not going to bother you with statistics or any policy frameworks. Instead, I'm going to give you, for start, two names, and the names is Artur and Shalua. And who is Artur and who is Shalua? Artur is a Polish construction worker who was arrested in Germany. There was no lawyer present during the investigation. There was no translator. He didn't understand the charges, as illustrated by the presentation of Nicola, which was excellent. And finally, he got 18 months in prison. On the other hand, Shalua is a Moroccan student in Spain, wrongfully accused. There was no legal aid for 72 hours. And as a consequence, she confessed under pressure. You may ask me, are these, let's say, examples fictional or real? Of course, they are fictional, but they are inspired by true events. I mean, by real situations. I mean, such things do happen in Europe. And when they do, the consequences are devastating, because as it is written in the slide, and you can read that, justice without lawyers is just ice. So the first phenomenon is the legal aid desert. What is the legal aid desert? There was an investigation of the CCBE in 2023 that revealed very, very interesting elements, I could say. First of all, in 76 districts of the European Union, there was no available criminal legal aid lawyer at the critical moment of the arrest and the following hours. And the problem was more intense in non-urban areas where there has been delays up to 72 hours to find a lawyer to come to the police station. And another element is that in some areas, there was only one lawyer in a radius of 200 kilometers, for example. So this map of the legal aid deserts, of these desert zones deprived of legal aid.
I'm going to interrupt you, Alexis. Your slides, you're not sure. I know all these things are highlighted in your slides and you're not moving them on. I don't know.
No. It's not on the slide.
Ah, okay. I apologize for interrupting you. Carry on.
No, not a problem. I mean, I'm still on the second slide about the legal aid desert. And I say that these findings should have shocked the policymakers, the EU policymakers. Have you seen the politicians to worry about that? Have you seen the legislators to worry about that? Have you seen the the public opinion, let's say, to worry about that? They should, definitely. And according to these findings, Eastern and Southern Europe are mostly affected, but I can say that no region remains immune from these situations. As it is written, as one defender once told me with a great sense of irony, that in some parts of Europe, it is more likely to find a unicorn than a legal aid lawyer. And you can understand that this shortage leads to delays, detentions, and wrongful outcomes. So the problem, what is the problem? First of all, money is the problem, you know? What is the problem? That lawyers walk away from legal aid schemes. As it is written, you cannot expect a Rolls-Royce defense on a bicycle budget. And I'm sure you all have your experiences, but we can say, and we can all agree, unless we don't, that the legal aid rates are very low, not to say contrary to reasonable legal fees. Some figures that I promised not to give you is that the crisis can be, let's say, categorized in facts and numbers, such as that the legal aid rates in some regions, in some states, is as low as 25 euros per hour. In some is more. I know that there are many Greeks here that can say more about that, and I will come to that.
Alexis, I'm going to interrupt you again. I know, because I'm following your slides. All this is shown on your slides, but you're still on the very first opening slide for us to see. So I think you're not showing through your slides. And I can say to the audience that...
I will share again, Jonathan.
Fine. All of this information which Alexis is giving is on his slides. And I'm sorry to interrupt you, Alexis.
Not a problem. Can you see now my slides?
Yeah, we see them in 3 of them, but we see, for instance, the money problem. What you were just talking to is now there, but it's with 2 other slides. Do you want Vasilis to take over and show your slides? He can easily do that.
Let me see if I can fix that. I doubt. It happens all the time, Jonathan. So
Don't worry. Look, Vasilis, take over, show Alexis slides, go to the relevant slides,
Now in slide number 4.
Right. You need to stop sharing, Alexis, and Vasilis needs to take over.
Okay.
There we go. There you go.
Okay.
Fine. Thank you. Sorry to interrupt.
Not a problem. Not a problem. So, as a consequence, 38% of the competent lawyers, let's say, quit, and there is a drop in participating lawyers since 2020. And of course, as I told you, and there are many Greeks here that you witness that and experience that. There is the Greek legal aid payment scandal. And why I say scandal? Because legal aid payments were not processed for 4 years. 4 years. I know that in some member states there are some delays for 4 months. But in Greece, from 2018 till 2022, payments were not done, were not happening. And the payments only resumed recently after the lawyers' associations went on strike. And they went on strike, on indefinite strike, to press the government to pay the invoices to the legal aid lawyers that were not paid and were not covered for 4 years. For 4 years. So, Vasilis, if you want to move to slide number 4, I'm ready for that. So, what are the demands of the CCBE for fair pay and fair justice? The first, let's say, demand is the rates to be tied to case complexity. That's one. To have annual inflation adjustments. That's number 2. These proposals may seem unrealistic or very romantic to you, but I'm sure that there are some basic requirements for a functioning system. And also the guaranteed payment timelines. It's something that has to be done, of course. Also minimum rate floors across EU, and not to have big discrepancies between, let's say, Southern Europe and Northern Europe, or Eastern Europe and Western part, and travel compensation for rural areas. I don't know if it is happening. I've never seen that, although it should have take place. So, Vasily, if you are ready for number 6. If you are ready for number 6, I'm going to talk about the ghost defendant scandal, another scandal. I may be exaggerating, or I like to use this word, but I'm afraid the situation, let's say, is not so optimal as it should be. And what I mean by the ghost defendant scandal in legal aid cases. Also, the CCBE investigation in 2023 revealed that, first of all, sometimes lawyers are assigned of dozens of cases daily. The same lawyer, many cases on the same day. On the contrary, in other regions, like the southern regions, like Greece, legal aid lawyers sometimes receive cases once per year, twice per year. Correct me if I'm wrong. And another aspect of the ghost defendant scandal is that many defendants never meeting their client before the court, which is not so good, or others receiving just minutes for the case review. So this ghost defendant scandal or phenomenon happens when overwhelmed legal aid lawyers cannot handle their caseload effectively. I've spoken with defendants who never actually had the chance to meet their lawyer before the trial and to meet their lawyer face to face or to have a meeting with them. And this is a very, in my view, very serious and implicated situation. And I will choose my words very carefully because I want to be super clear on that. This is not the fault of the lawyers. This is not the fault of dedicated attorneys. It is rather the fault of a system, of a failed system that, let's say, treats the legal representation as just a box to check, just a box to check, rather than a fundamental right. I mean, they treat legal aid as a formality, as something that has to be done, as something that we have to do in order not to get penalties from the Commission or the EU, or to make appearances that we have complied with EU standards. But what about the implementation? What about effectiveness? What about what really happens? I don't know. It's up to you, but Are there any guarantees in your domestic law about effective and quality representation? And what happens if these elements are missing? I don't know. I'm waiting for your replies on that. So Vasily, number 7, I think, is ready to go. And what are the measures of the quality reform? And what are the necessary measures, in my view, of course? The first of all is for some regions and some states where, let's say, the caseload is a problem, the workload is a problem, to be imposed maximum caseload caps, so every local lawyer can participate with a number of cases that can treat with quality. Secondly, mandatory pretrial client meetings. I know that dedicated attorneys do that, and they do it regularly. But in my view, it is, let's say, necessary for the law to have a provision on that, because there is not only the rule, there are also exceptions. And it's good to have mandatory provisions for quality representation. Also, regular quality reviews. This is, let's say, a very broad proposition, in the meaning that it does not propose something concrete, but I think it is up to you, the practitioners, up to the bar associations, up to the, let's say, to the governments and the member states to find and to identify the proper measures and mechanism for quality review, and not only rely on reports to the bar associations that rarely happen, and sometimes these reports that do happen from the clients, sometimes they lack objectivity, and they lack knowledge, because the client can report to the bar association when their case is lost, or when they think that their case is lost. So we rather need mechanism from, let's say, to have a review from peers, from people in the field. Also, specialized training requirements for legal aid schemes. Of course, this does not apply to you, because since you are here, you are very keen to explore and to find out what is happening abroad in EU member states. And I'm sure that you already know that the knowledge is a very powerful tool for the defense of your clients. But let's say we have to have provisions not only for the rule, but also for the exceptions. And also independent oversight boards that will, let's say, that will overview and have a supervision over the mechanism of the legal aid. And this mechanism has to be, in my view, not coming from the executive, rather from our own field, from our bar associations, to guarantee the independence of our bar associations and not to have any interference from the executive. But on the other hand, we should guarantee effectiveness, objectivity, and and impartial review, because there are many issues that need to be reviewed or monitored by an independent body, like the selection, what are the criteria for the selection of lawyers, because I've met many debates about let's say, the criteria for which the legal aid lawyer is called to defend a case. In some countries is more strong, in others is weak, but at least I think that we should have established criteria, established protocols, established practices that leave no room for any objection or any idea that something fishy is happening in there. because there is also the conception that the legal aid is a source of income, is an easy source of income. I don't share this idea. I share the idea that legal aid is, let's say, a very noble way to contribute to the defense of the vulnerable, first of all, and secondly, is a good way to get experience, to get cases, to have some financial, let's say, gains, and also contributing to the greatest good and to the quality of justice. So, Vasily, if you want to move to number 4. So what is about the CCBE Criminal Legal Aid Manifesto? And there are 5 core demands. 5 core demands. First of all, legal aid within 2 hours of arrest. You may smile, you may laugh, you may think it is unrealistic or romantic, but I know that deep inside you, you know that it is rather necessary for the proper defense of the cases, because the most arbitrary moves, the most violation of the rights happens immediately after the arrest, when the suspect is at the hands of the investigation bodies, alone, without proper advice and without proper encouragement to do the right thing. And within the 2 hours of arrest, most of the incriminating statements do take place. And sometimes these statements are overturned, as we showed by the previous, by Salvador's presentation. And then we have a lot of work to do to overturn them, to get compensation, to clear the name, or anything like that. Also, another demand is to have a client choice from a certified panel of lawyers. The caseload limits to ensure quality. And of course, to have specialized defense training and certification. I know there are many training programs. I don't know if they are targeted specifically to legal aid lawyers or not. And I'm not confident that there are certification protocols for legal aid lawyers as well. But this is up to you to let me know. So, Vasily, we are going to number 9, if you agree. So, if all these measures were to be implemented, ideally, romantically, by miracle, I don't know. I mean, we could revisit Arthur's case. You remember Arthur? It was the fictional character that it was used in the start, at the start of the presentation, to show how important it is to have legal aid assistance in the first hours of the arrest, not to have any wrongful outcomes. So cases like Arthur's could be revisited, reopened, and with translation and qualified legal aid lawyer, an outcome could be different. And justice is being restored. Okay, I wrote that, but I can't believe how naive I was to write that. But ideally, that is to have it to be done. But the practice, as you know better than me, is far away from the theory. And I will share a story of mine. There was a defendant that once told me, in a form of complaint rather than a statement, that they told me, I thought that I was innocent and I thought that was enough. But I was wrong. You need a good lawyer, even if you are innocent. And I say, you need a good lawyer, especially if you are innocent. Okay? And you know how the practice is. The guilty person has, in a way, has nothing to lose because they are guilty, and the innocent people have a lot to lose because they have done anything. So you definitely need a good lawyer if you are innocent, especially if you are innocent, or even if you are guilty, because that's a concept too that is open to debate. But if you don't have the income, if you don't have the resources, then you need a good legal aid lawyer. And though this insight captures why legal aid matters for everybody, for the guilty, for innocent, for the defendants, and generally for the system of justice.
We need to end, Alexis. I'm sorry, because
I will end in 50 seconds.
Fine.
If Vasilis will go on to the next slide. So if you are convinced to take action, to be part of the solution, to be the change that you want to see in others, in legal aid matters, for legal professionals, volunteer for training and certification, you already did. Advocate with your bar association. Bar associations exist for a reason, and that's part of their work, so they can do that. And also, if you are part of the civil society, you can monitor court cases and representation quality, educate vulnerable communities about their rights. Legal aid protects everyone. Legal aid matters. You never think you'll need it until you do. So I encourage everyone in this room to find their place in this movement if they wish so. If not, it's okay. But if you decide to find your way in this movement, even individually, I would like to congratulate you, because the quality of legal aid matters, defines the quality of justice, and the quality of justice is something definitely good for everyone. So that was it. I mean, I'm open to any questions or anything else. I mean, I hope this presentation, not to be the final word, but let's say a beginning of a conversation that we can have here in the chat box, of course, or through emails or individual. I mean, any one of us to have an internal, let's say, discussion and internal thinking about that, and to see how we can fit on that. If we don't, it's rather okay for everybody. So thank you very much.
Thank you so much, Alexis. I'm sorry about the early interruption. All went perfectly. Excellent presentation. Very clear and wonderful. Thank you. Thank you to all our speakers. We ought to end now. Thank you to all our speakers for their wonderful presentations. I will give a symbolic round of applause on behalf of all of you for it. Thank you to you, our participants, as well. Just to repeat, the video was recorded. You'll be able to see the recording, hopefully by the end of today, plus all the excellent presentations, which are full of so much information. Thank you to everybody. That is the end now of this webinar, and I hope you will join us on a future occasion for other webinars. Thank you, everybody, and goodbye.